We're good to go.
He said count down to 10, so you're good to go whenever you want.
All right. Good evening. I'm Kathleen O'Donnell, and you're at the meeting of the Zoning Board of Appeals for the Town of Milton. And tonight's hearing with me, I'm the acting chair, and with me is Ted Daber to my right and Nicholas Gray to my left. We have two matters that we are hearing this evening. The first one is an application by Michael and Pamela Peters for a special permit and variances to allow for the construction of an addition on the rear of their home at 49 Briarfield Road. That would be creating a 484 square foot temporary in-law apartment for Mrs. Peters' mother, with one bedroom, a living room, kitchen, and one bathroom. And then we also would have a permission to have that as a temporary apartment, which requires a variance under our zoning bylaws because in this case, our zoning bylaw requires the temporary apartments are located in the existing residential structure. In this particular case, the applicants are proposing to do an addition on the rear, not construct that temporary apartment in the existing house. So if people would come up and speak, the microphones that are here in the room are actually for the television, not for other people in the room who probably hear you just fine. But if you would sort of say who you are and your address and yeah, just sort of have them come and sit. In the record, thanks, Ed. In the record, we do have a denial letter from the building commissioner dated July 6th, 2017, denying their application to get a building permit for this addition. We also have a letter from counsel for the applicants, Marion McGettrick, dated July 11, 2018, describing this application for variances and the special permit. I believe that the attachments included a plot plan of the property prepared by Antonino Land Surveyors. I don't see a date on that. Oh yeah, January 17th, 2018. We have additions and alterations to 49 Briarfield Street done by somebody whose name I cannot read.
Larger copies for you, if that helps.
That would be great. We were just sort of searching around for larger copies.
I guessed correctly, so.
Thank you. Okay, great. And then in addition, we have the property record card from the Town of Milton Assessor's Office and a copy of the assessor's plan. And I believe that that completes the record.
Yes,
Good evening,
Good
Mary.
evening.
Nice to see you again.
thank you. I'm Mary McKettrick, and I represent the applicants. The whole family is here tonight. So up here with me at the table is Michael Peters, Diane Barry's mother.
No.
I'm sorry, Diane Barry, who is Mrs. Peters' mother. And then in the audience is Mrs. Peters and their two children, who are Penny and Henry. Just want to introduce everybody. And the architect, by the way, is Joseph Genduso. He
Sorry,
lives in Milton. I don't, that was a little bit hard to read on the plan.
Copy was hard to read.
So this, there have been a couple of, I'm sorry,
Could you spell that while thinking of it?
Genduso, and the first name is Joseph.
Genduso.
So
Okay, great.
I have handled a couple of applications having some similarities to this one previously, and also some other temporary apartment applications that were just under the special permit provision of the bylaw. So in this case, the applicants are proposing to construct a one-story addition to the rear of their home. When it's not a temporary apartment, the one-story addition would be a study and a family room, is that right? And there would be, the bathroom would remain as it is. The kitchen would be removed, which would have to be placed there for the temporary apartment use. What they would like to do, because they are all currently together, and Mrs. Barry does take care of the children who are young, so the sooner she's able to be moved into this addition, the better things will work for the whole family. She was in her own home, is that correct?
In Georgia,
At one time,
I was.
yes.
But the last 2 years in Georgia, before we moved here last year, I did move in with them. They had an apartment in the basement of their home, and it was already there, and I moved in, and I helped with the children.
And that's a different home? Is that, or is that this?
No, that's in Georgia. That was the home in Georgia.
That was while you were in Georgia after you sold your house?
Right.
Yeah.
We
So
moved
that,
up here almost a year ago exactly, this month. So-
Oh, wow.
the family has been living together for some time. That's what I'm trying to establish. And so they've, now Peters have moved into a new house, or a different house in Milton on Briarfield Road. It's on a small lot. And so in order to, and the current house does observe all of the current required setbacks. The garage does not. The garage is in the right-hand corner in the back of the lot. But in order to add on to the back of the house, it's necessary to have any kind of addition of reasonable size to intrude into the rear setback and the side setback as proposed in this application. And this would be if they wanted to do the addition and create the family room and study and bathroom. And likewise, the same intrusion, the same building is going to be necessary to have the temporary apartment. There's, I think if you look on the assessor's map, it's helpful here to visualize where this addition would be in relation to the properties next to it, because in the back, it's near the driveway, the end of the driveway. On the side closest to the addition, it's along the driveway.
Right.
So it doesn't happen that this addition is very close to the residences on either side. In addition to that, though, the applicants have met with their neighbors, and they have letters of support, which we're going to give you.
Great.
So, to the extent we've been able to determine, the neighbors do support this application, and I don't know if there's anyone here tonight who's going to talk, but the letters certainly express their support. Let's see,
The letters are everybody that abuts our property, and then the two houses directly across the street.
Okay, and 50 Briarfield, is that, as you're looking at your house, is that the one on the left, which is going to be most impacted by the addition?
What's the name on 50 Briar?
Geller?
50's across the street.
Yeah.
Oh,
If
sorry.
I'm reading this right.
49, yeah.
47 and 51 on,
I think 51 is the,
on the left as you face it from Briarfield.
Okay. Okay, and we do have a letter from them.
the rear, I think is the name.
Hard to see, the signature, not very clear.
well, maybe we should
Yeah.
print it in, or you could.
Because, you know, as just sort of looking at the plans, that seems to be the neighbor that would be the most impacted, so that's why I asked.
Okay. Yeah. So in other respects, the temporary apartment bylaw has a lot of requirements, and the applicants intend to comply with all of the requirements, with the exception of the one that says the in-law apartment has to be created in an existing house. If they were to build the addition and then come in and apply, they still need a variance, by the way, to build the addition, so they need to be before you. And then they could build it, that they would have to then come back and apply again for the temporary apartment for a special permit. And there, you know, of course, it would take longer. It would also be more expensive for them, because what the building department requires when you build an addition like this is that you not put in the pipes and everything that you would, if you need connections, say for a kitchen sink or something else in the kitchen. You can't put them in because you don't have a permit for a temporary apartment. And so in other cases, when we've looked at this, the problem has been there's additional expense. It's a considerable delay, having to come back to the board twice. And in the end, the neighbors support it. It seems more appropriate, or at least there's some justification for going ahead and creating the relief in this case to allow everything to happen at the same time. It's still going to be a 4-year limited permit. They have to come back within the, before the end of 4 years and apply again if they want to continue the use. And if they discontinue the use, they have to notify the building department right away and remove what constitutes the apartment. The building department usually says that's the sink and the stove, but refrigerator, whatever. Their plan should show both setups. We're supposed to give you that. And that's what the building department requires as well in this case. The other requirements in the bylaw relate to things like parking, and availability of parking. There's a driveway that runs up the side of the lot. It does end in a garage, but even in the driveway, there's room for 3 cars, and there are 3 cars. Is that correct?
Currently,
The
right.
family has 3 cars, including the mother-in-law's car. So the entrance, as you can see from the design, will be a common entrance at the back, which will actually be replaced. They're taking down at least half of the deck that's in the back now. And then the entrance is going to be in back there where the deck is. You'll be able to go into this part of the house after you go in, or you'd be able to go back into the house, the regular house. And you enter it in exactly the same way once it becomes a family room and a study and that kind of thing. So there will be no additional parking or any change in parking arrangements as a result of allowing the temporary apartment. At 495 square feet, it meets the bylaw size limitations. The existing floor area of the house is 1885 square feet. With the new addition, it'll be 2380. So that 495 square feet is 20.1% of the floor area of the proposed finished floor area of the dwelling, and it can't be more than 30%. It also, whichever is larger or smaller, in this case, it's that 30%, because otherwise you could go up to 800 square feet. So, and finally, I guess I already said this, but, one thing that I think it is important to understand is that once you do an addition with a temporary apartment in it, you cannot do another addition to your house. And that's a restriction, and it's important to understand. And it's another reason why, in these cases where it's a relatively small lot and one of these older homes that predates the zoning bylaw, they're planning what they want to do with the house in order to live in it together. And, if they even were to try to create a temporary apartment in the house, they're going to want to enlarge this house for the size of their family. So they're trying to plan for the long term and do it at the same time.
Any questions?
Don't think so at the moment.
Is that the end of the presentation? Yeah, I have some
Yeah.
questions. Okay. Well, I guess my first one that I should mention is noticing going through the bylaw provision. There is there's a sentence in D which says, and this is what I have the question about. These designs shall show, and it says first, that the temporary apartment will be created without exterior modifications to the dwelling, except as may be required for safety. And I guess my question is, the fact that there's an addition, is that an exterior modification that technically would require a variance?
Yes, I think so, although the focus is generally on the wording that says it has to be contained within the existing house. But the other reason that language is in there, at least in my understanding, is that they don't want you to redesign the exterior of the house when you create the apartment that's supposed to be inside the house. That's what the town meeting, at least, was trying to do when they wrote that language in. So they don't, the bylaw says that, for example, you can't create a new exterior entrance projecting out from the house. That's the way I would read it. I do think it includes, though, what we're asking for. And so, we could, I don't specifically refer to that provision. I don't refer to either provision. I say that we're asking for relief in order to create the apartment in a new addition, which is clearly exterior to the existing
No,
house.
I mean, well, it does mention F, which is the other one. But that was my question. I mean, and I haven't come up on this before. I mean, and I'd ask, I don't know whether now or not, but my colleagues here, does that technically require another variance under that section? think about it, and I can, unless you have a,
Well, I'm just
'cause
thinking.
I can't decide it myself.
Yeah, yeah, I mean, I'm thinking that I have had 3, I think, other hearings of temporary apartments. And even if they are in the dwelling, they have changed the exterior. You know, you've added windows, you've added, a deck off the back, any number of things. So there have been some exterior alterations, even if you have put it in the house without doing an addition.
The other issue here is, well, the way I proceed with these things is that I go to the building inspector, and somebody files an application, sometimes it's me, sometimes it's the applicant. The building inspector reviews the application and determines what requires relief. So the denial letter frames the relief required. That's not to say there couldn't be an error or something missing. He's done a number of these, and I happen to have done 4, I think, as an attorney. And this issue he has not identified this as an issue requiring a separate variance. I've done 3 where there were simultaneous construction. But I think it's always good to be careful, so if you feel that it should be included as a specific reference, then we could include it.
Well,
But
yeah, I don't want it to be.
I don't think he interprets it
I don't
that
want it to
way.
be problematic,
Yeah.
in terms of the variance, once you construct it, that not all of the variances necessary are there. That's that was my question, so.
Well, it does require exterior modifications. No one else has picked up on that language. I can't say that is very careful reading. It really is. And the building inspector hasn't picked up on it. I think that it would be, that we're asking for a variance to allow an exterior addition to be built, and the exterior addition is going to contain the in-law apartment, so it clearly involves exterior changes.
Yeah, I would say it clearly, there's no way you could argue that this particular addition isn't an exterior modification, beyond what's required for safety, right? I mean, that's, I understand what Attorney McKettrick is saying,
No, I do too.
but I think a plain reading it's pretty hard to argue that the addition being contemplated is not an exterior modification.
Right. But I think that if you sort of
We grant one, we,
telescope the decision so that you're approving the addition
yeah,
first,
yeah.
and then the temporary apartment in the addition,
It should cover it.
I think that would, don't you think that would?
It's merely whether we mention this particular paragraph as well.
Right.
I would say.
If that's the way the two, I haven't come up with the issue before, as I said. I've been on, panels with a couple of these before too, and, at times when there are window issues and things that that's mentioned and that's part of the variance, but, I understand this is a little bit different.
Could you just, I would appreciate it, since I don't have it in front of me, just read the sentence to me again? I just want to focus on what we should be saying. Oh, thank you. Thank you. I've got it.
Okay.
It's in the middle of D.
Yeah.
Yeah.
4 lines down, 5 lines down.
Well,
Yeah.
In the context, it's talking about doors and windows, right? I mean, I think that's,
yes, I mean, the idea is that it's supposed to still look like the home that it was before, when you have an existing home. That was the intent. I mean, I was at town meeting, when some of you probably were too.
I think I was.
I
know it was.
think it's a good idea to,
Well, I mean, I know
it's-
that, yesterday, in the hearing that we had yesterday, we made reference to the master plan, and I know that in the master plan, there was a goal stated in that plan to allow for flexibility, to allow different housing types, and also to allow for temporary apartments to handle, our family members as required, so. As I said, I think if I drafted the opinion with the decision with the variance first, and then the temporary apartment second,
Yeah.
I think that covers that.
I don't want someone to be able to argue that it's part of the corrections for removing the special, the temporary apartment, that the entire addition has to
Yeah.
go, right?
Yeah,
That-
there you
That
go.
would sort of be.
That's
Which-
why I'm raising it.
Yeah,
Yeah.
Yeah.
Right.
Yeah, that's a good point. I mean, it's interesting.
Which would be drastic, you know?
This language is really, there's all kinds of things that you might not think of when you're writing. This is when you're writing a new zoning bylaw, I'm talking about that.
Yeah, that's true.
But it's important.
And the bylaw's already pretty long, this one.
It is, yeah.
Okay, to get on to some other, so I think you said, and the plans seem to show about half of the deck the existing deck is being removed, but what's left is not being moved any further back towards, I mean, I assume there'll have to be some, is there going to be any reconstruction of what's there? or-
I don't know that we'll be able to remove half the deck and keep the other half
That's
there.
what I mean, yeah.
We'll have to replace that half, but the footprint would remain the same. That was our architect's idea, was that it would stay the same footprint, but we would have to tear that down. If you look at it, you can tell that it's not one that will survive missing half of it.
Right, and do I remember correctly that the existing footprint is compliant with the setback, the rear and side setback requirements?
that should
So
show
if it's
on the
within
plot
this existing footprint, there's no, okay. Let me see. Just out of curiosity, when it says kitchen appliances, will there be, there'll be plumbing in there too, I presume, for the
Correct.
kitchen and
Right.
everything? And the plumbing will stay, or when it's changed? or-
So when it's changed, the way I understood it, in talking to Mr. Prondak, was that to convert it from a kitchen to not a kitchen really was taking out the range and the utilities that go towards that. The sink wasn't mentioned, but if we need to take out the sink, then we'll take out the plumbing for the sink as well.
Yeah, I think maybe the language does have to do with food preparation, right?
Yeah.
Separate, rather than, maybe the sink isn't,
It's the sink and
You
the
could
stove.
have,
and-
yeah, I mean, you could have a
Yeah.
bar
Right.
with a sink
Yep.
and a refrigerator. I think
that's-
it's the
I think the
stove is
language
the
is,
issue.
does
Kitchen.
relate to food
Yeah.
preparation and not to things other than that. Let me just go
But
through
I don't
this.
think you have to take the plumbing and stuff out. I think you just
No,
cap
that's
it.
that's what I'm asking.
Yeah.
What
I think
what
you
was,
just
what
cap
was
it.
intended, yeah.
That tends to, yeah, that's the kind of thing the building department does decide.
Yeah.
It's interesting, I haven't had one end yet that I have worked with, and so I don't know, but I think that they wouldn't do that, partly because it would involve opening up the wall, and all you want to do is take the plumbing out and clean it up, make it as easy as possible. The idea is the conversion back is supposed to be as easy as possible.
Can I say something? I hope we don't have to worry about this for a very long time.
Exactly.
Knock on wood.
It's true.
Okay, so just so I have it clarified, if you wouldn't mind, Marion or Mr. Peters. So when we're looking at the ones that you have letters to, the neighbors, and it's, I'm looking at the assessor's plan, and you're 49. So you have letters from 47, which is on the right as you face your house from Briarfield,
Correct.
and
Yes.
one from 51,
Yes.
and then 40 and 50, which are on the
Across the
other
street,
side,
correct.
across the street.
Mm-hmm.
Okay, and not, but
We also-
not
we
in the
have-
back on
We have the
Columbia.
three back.
Yes.
Oh, you have the
Three
three back too?
on the
Great,
back.
okay. I
Seven.
figured it was easier to ask than
Yeah,
to
seven,
try to
yeah.
read those during the.
7, 3, and 3, 7, and 3, 5, and 7.
We did a lap around the house.
Great.
and said,
No, that's
talked about-
terrific.
And we talked to him much earlier, before we got into this process, just to make sure that everybody was okay. So nobody raised any objections, so.
Okay, those are all the questions I have.
None,
None?
I don't think so.
Does anybody want to speak in the audience in favor? Anybody want to speak against? Yeah. Make note of Mrs.
I'm
Very-
hearing another issue that sounds like.
Thank you.
I was hoping
Gives-
we were gonna have
Yeah, we'll just ask one more. Okay.
Yeah.
And the construction is all going to be consistent in appearance with the existing house, is that correct? Yeah, okay.
And the trees staying up in the backyard
We have a tree in the front yard that's
Yeah.
staying, correct, yeah.
and in the back?
We don't have a tree. in the
That's in
backyard.
the neighbors?
Yes,
Okay.
correct, yeah.
That's,
Okay.
Yeah, I mean, there was one, the only question I have, which is so painfully obvious, but it's in the requirements, is that we have to establish 50%, somebody, that there's ownership, right?
Yes.
In the past, that's been done with a deed being filed or something that would show
Yeah, I
that.
didn't give you a copy of the deed.
No.
I
Well,
will
you may have-
supply it.
maybe it didn't come out to me, so.
I think I
Well,
have
I'm
it.
assuming
It's not
that
in the
that's.
package that we got.
that's-
I may have it here, and if I do, I'll just hand it over, and if not, I will deliver it to the office tomorrow.
That was the only, just so we've checked all the boxes. Established relationship. Plan to get
think I brought it.
move it. The cars. I'm fine.
Okay, so hearing nothing else, I'll close the hearing.
I don't have anything to add, except that I'm just looking for the deed for it. I always look up the title history for these cases, and I don't always provide it when I don't think it's necessary. I wasn't arguing pre-existing non-conforming use. I knew they needed the variance. I have it. I will drop it off at the office tomorrow, so it will be in your file. And it establishes that Mr. and Mrs. Peters, well, you can explain the current ownership. That might
Yeah,
be helpful.
my wife and I have a mortgage on the house,
Yep.
so that's the ownership.
Right, and their names are on the property record,
Yeah, I mean,
on the assessment
yeah,
record.
that's fine.
And the
For
deed
With the
reference, but I'll
book and
provide a
page,
copy.
yes.
Okay.
Okay. Anything else? We'll close the hearing on that and discuss amongst ourselves. What is your inclination?
Well, this is one of those situations where a literal interpretation of the bylaw would require them to build an addition, and so it's part of the existing structure, and then come back later to get a special permit to install the apartment. And I suppose we could be very strict about it and say that that's what should be done because that's what the bylaw says. In this particular case, because all of the neighbors have the neighbors all surrounding the property have agreed to the plan, and because it clearly would be more expensive to build the addition without the plumbing to be able to have the kitchen. It just seems to be kind of a hardship.
Yeah.
And I know that the town meeting thought very, very hard about this particular bylaw, this particular provision. I remember we were there, I remember it went on, there was a lot of discussion about it, and it's very detailed.
I can only imagine.
And but my sense is that in this particular case, it's kind of a lot to ask to make them come in for the dimensional variances, which would, with the sense that we normally have, are routinely granted, to be able to build the addition and then come back again
Yeah.
to do it again. So I think in this case, I'd be in favor of granting the required dimensional variances, which we didn't talk a whole lot about, but also the variance to the requirement of having it be within the existing structure, and then also finally the special permit to allow the construction of the, it makes more sense from an economic point of view, from a disruption point of view for the family. And given the childcare role that Mrs. Barry, Ms. Barry, yeah, plays, especially and the extra costs and all that, I think I feel comfortable granting the relief requested.
I agree with everything that Nick has said. In addition, would note with the size of the lot, it's very difficult on a lot that size to have a house with adequate room without encroaching.
That's true.
In an addition like this, without encroaching on the one setback requirement or another. It certainly is something that appears to be needed and warranted. It, I think, meets the requirements for a special permit, is not adversely affecting the neighboring properties, and for the dimensional variances as well. And with respect to, I presume, with respect to what you raised about the deed, I presume we could make it subject to receiving, right, a copy of the deed or something.
Yeah, I
if
mean,
we need to,
there's
or
enough
whatever.
other
Yeah.
evidence in the record
Right,
that
right.
I
Well,
don't think is
just-
an issue, but just to make sure that we
Yeah,
had
well-
every element met.
Right, and the other conditions, some of them can be put in there about no borders and, you know, some of the other things that have to be complied with during the
Right.
term, and on that basis, with the reasonable conditions in there and compliance with Section 9, I'd be inclined to vote in favor of it.
Yeah, I had actually sort of, looked at this issue a number of times, I think, with Ms. McEttrick, Attorney McEttrick on the other side of the accessory apartments and temporary apartments. I am aware of the fact that other houses on that street have had extensions and additions as well. I could tell that from watching Google Earth. So.
In your spare time.
In my spare time. So I appreciate the comments made by the fellow members of the ZBA on the reasoning behind why we would grant it. And I do think that it would be illogical and an economic hardship to sort of make you go through the two-step process. So, as I said, I think if we craft our decision to give, as Mr. Gray mentioned, the variances for the dimensional requirements and then allow the special permit, I think that achieves the same result on one piece of paper in one hearing instead of two. So I'm in favor. And a vote? All in favor?
Aye.
Aye. Congratulations.
Thank you very much.
So it'll take some time for people to issue, get a decision together, and then, as Ms. McEttrick knows, you get a copy of it, you record it at the Registry of Deeds. And the important thing to remember is that there's a special permit that has a time limit on it. And don't wait until it expires before you come back to say you need it renewed. You have to do that before it expires. So don't wait today,
Like 3 months before? or-
yeah, 6 months, something.
Long enough for the notice to be given
Yeah.
and,
Install a countdown clock.
Yeah, exactly.
that's right.
Like when the bank gives you those things that you can count off and sort of your payments, well, make sure that you keep a track of that date.
You're also required to notify the building department every year, I don't know who's doing this, every year that you are still using the apartment. It's
Okay.
just a 2-sentence letter,
Okay.
but you should put a little reminder to yourself
And
to
doing it
do
yearly
that,
will
and that'll help you remember the
Remember the fourth, yeah.
expiration date too. So,
Thank you very much.
Absolutely, thank
you.
And thank you for bringing those letters from the neighbors. That is very helpful for us.
Thank you.
Congratulations.
Thank you.
These kids were so good.
Exciting hearing.
Okay.
It's helpful to have the larger plan, so you.
It does help, yeah.
This is a little clearer to read than the other one. So who wants to write this one? Any takers?
If within the next few weeks, I would not be able to touch it with everything I got going on.
And I know you have the sun going up. Yeah.
I wouldn't, yeah, I mean, I wouldn't mind doing it, but I wouldn't be able to touch it before.
I'm taking 3 days off next week, but we'll work on it.
I'm already signed up to do one from yesterday.
Yeah, that's
so
fine.
If you don't mind,
Not at all.
that would be great. Thank you. Now, our 7:45 hearing, only 20 minutes off, is Brush Hill Mansions LLC. And this is a request for an enforcement action, requesting zoning enforcement by the Milton Building Commissioner pursuant to Chapter 7 of Chapter 40A. The applicant owns land down gradient from property at the Mansions at Brush Hill Condominium Trust at 333 Brush Hill Road. The Mansions at Brush Hill Road Condominium Trust received a special permit with restrictions referenced in 2 plans. The special permit provides there shall not be any material changes in these plans without the prior approval of the planning board. And this was specifically limiting any construction, alteration, or placement of roads, driveways, paths, drains, and excavation and filling. And the applicant, Brush Hill Mansions LLC, alleges that the trust, condominium trust, without any permits, approvals, or revised plans, has materially altered 333 Brush Hill Road by adding paved parking, additional paved roadways, and that the trust, without any permit or drainage analysis or plans, has installed granite curbing throughout the roadway, and that all of these improvements that have been made have created drainage problems for the down gradient owner. And they've altered the stormwater characteristics of the property, causing substantial drainage and stormwater problems to the applicant, Brush Hill Mansions. So it turns out that the Brush Hill Mansions LLC had sent 2 letters to the building commissioner requesting enforcement of the zoning bylaws and enforcement of the conditions of the 1990 special permit, and that they alleged that the building commissioner failed to act. So we are been asked to take a response to this. In the record, unfortunately, we have this notice of appeal that was filed on June 15th with significant information about the roadways, the construction, drainage analysis, requests for pictures, zoning enforcement. And then we have simultaneously with the action by the building inspector, the building commissioner, on July 22nd of 2018, specifically addressing the alleged violations and taking the action that the applicant had requested, we also got a letter from the applicant asking for a continuance. And they must have just sort of passed in the mail. In addition, we had a response from the attorney for the condominium association, attorney David Udy of Maroney, Shaughnessy, and Udy, and providing a response to this notice of appeal, providing information on what work they had done and the ongoing dispute apparently between the condominium trust and the owner of the downgrading property, which has been going on apparently for some time. I understand from counsel for the applicant that Mr. Udy is on vacation this week. So what happened as a result of all of this, the appeal to us to say the building inspector hasn't done an enforcement letter, and getting the enforcement letter, I had a long conversation with the building commissioner, and I said, you know, I don't know that we've got jurisdiction. If they're asking for an enforcement action, and you've done the enforcement action, what can we chat about, essentially? Counsel for the applicant contacted me directly and asked if we would please just continue this hearing. He believes that there is some negotiations or effort between the condominium trust and Mansions, Brush Hill Mansions, to work out some sort of arrangement. So his request was for a continuance tonight. I know there are people in the audience here who, in the room, who would like to be heard, and we will do that. Perhaps, but we have said that in the hopes that these folks either work this out amongst themselves or are going back to the planning board, which has got the jurisdiction over, the special permit and any kind of changes to the special permit. I don't know that we have much of a role in that. So we've talked about postponing, continuing this at the request of the applicant to sometime in September, and I think, was it September 17th? is what we had talked about. Does that sort of, does that, I think, reflect the summary of facts at the moment?
As far as I know,
As
though.
I understand it,
yeah.
I mean, our job would have been to tell the building commissioner to start the enforcement action, which
Right.
already started.
Yeah.
That's pretty much what we could have done had we found for the person who's appealing.
Right, right.
Right, so-
And as I said, my inclination was to say, well, you know, we've got an enforcement letter, so it's kind of moot at this point, but said the applicant felt that it would be more helpful to the cause if we just continued it for
A month or so.
a month or so. So that's where we are at the moment on this particular appeal. So as you can see, I don't think the applicant's attorney is here. But yeah, absolutely, but the applicant's attorney and the condo attorney, neither of the attorneys are here.
No, actually, I have a question.
Yeah, oh, absolutely.
Yes,
So
thank you
if
so
you
much.
could come up?
Can I approach the bench?
Yes,
here?
absolutely.
Because I am a hard hearing.
Yeah. No, if you could come and sit down, give us your name and address.
Yeah, my name is Jorge Martinez.
Mm-hmm.
I'm one of the neighbors.
Okay.
I live on 3 or 4 Truman Parkway.
Uh-huh.
And this issue is affecting me in a big way.
Yeah.
As I understand, there is, everything is frozen in there right now, right? I
Mm-hmm.
mean, no activity whatsoever.
Well, I don't know whether there's activity, I mean, yes.
I don't see, I mean, it has more than a year
Yeah.
since, they have been building and doing, and I don't see any activity at all. Actually, there have been 3 buildings in there, right? 3 homes?
Yeah, the mansions, yeah.
Yeah, 3 homes, and then I'm directly, you know, like, I, on my backyard, one of them, actually 2 of them. But the reason what I'm saying I've been affected by it is because, remember the storm that we had on March? The biggest storm knocked out a big tree from the property, from the trustees, damaged their fence, and came all over on my fence, on my yard. I've been unable, I called several times over here to see if somebody can help on that. And then, it's, I don't know, I mean, it's impossible to contact anybody in there. And then that is affecting my yard big time, because it's a big tree with a lot of dry branches and everything.
It's still there?
Yeah, I mean, 2 of them actually. And then, and I'm very disappointed even with the trustees because, I don't know if you have time, but I can tell you that when I purchased this property in 1997, very beautiful property, big chunk of land. I was not aware that their fence was supposed to be more into my property.
Oh.
You know what I mean? So, and I was maintaining a big chunk of that property myself without knowing that. And then one day, trustees came over with a fence company, and they used throw a fence on it without letting me know anything, and some of my stuff was on the other side. And I didn't know what to do. But I spent a lot of money. You know, I have a vineyard, you know, with grapes and everything, gone. You know, all suddenly I was not even aware of it. So, I mean, he was kind of disappointed, and then obviously, emotionally it affected me a while because I was used to see a big chunk of my land. But anyway, I got over it, but still I spent a lot of money maintaining that for a while, removing the poison ivy, everything. And, you know, that's when they come over and they build the property, okay, fine, well, that's the way it is. Then I come issues with them. There are quite a few, in the past, a few trees fell down. I have to remove them. I call them, nobody take control of them. Damage the fence, it's their fence, but obviously it give a bad look into my yard, you know what I mean? I cannot show you a picture. You know, so if you don't mind. And I was wondering if they can do something about it or somebody can do something about that.
Well, it sounds like you, I mean, unfortunately, I hate to say it, I mean, we're all lawyers here, but it sounds like you probably need a lawyer, and hate to have to tell people they need a lawyer, but that's, I don't
That's-
think that's not in our jurisdiction, and certainly not
Yeah,
for tonight.
it looks ugly. The thing is that I have my grandson, he came to visit. He cannot go that area because,
Jeez.
And so, and this is the land that's owned by the mansions at Brush Hill
No, this is-
condominium or the
After
developer?
fence, you wanna look at it.
I'm kind of confused as to.
After the fence is, okay, let's see, this is the property right here, this is their side. The tree belonged to them, fell down, damaged their own fence and going into my property.
Yeah, but I'm just asking which one of these people? Is it the
Yeah, the condominiums.
condominium?
Condominiums. This
It's the
233.
condominium.
The tree was on the condominium property and it fell.
Fell in there. It's not the first time. It's about the third time this happens. So, I mean, I cannot continue doing this. You know what I mean? It's frustrating. They should maintain the fence. It's my understanding that when they put a fence, then you have like 6 inches or so much of their own land, so they can go and fix it if they have any problems. All that has, some of them has a lot of poison ivy around it. They never maintain anything. So this is kind of frustrating, I'm telling you. So, I mean, how do you think there's any way that I can solve this problem, or you can help me, or how this?
Well, as I said, I think, it sounds like this is a private matter between you and the condominium,
But I don't even have names of who's the trustees or anything. I don't,
Well, that's something, I mean,
Well,
maybe in the
we have the
papers,
name
right?
of the attorney who represents them.
It's in the papers.
Yeah.
Open to public inspection.
Yeah.
Yeah,
So this is the name of an address for the attorney that represents the condominium association.
that's the name, okay, so.
So this is a public record,
Yeah,
so
I can take a picture of that?
you could take a picture of it.
Okay, perfect.
Write them a letter.
So, probably the best thing is to hire an attorney.
Yeah.
But that's who he should get a hold, or he or she should get a
Start
hold of.
there. Free legal advice.
I'm just looking for a picture of the property
Yeah.
to see where it is.
Yeah, it is very frustrating because, then on top of that, when they started to build that, the water came through there into my yard. So,
Well, as I said, that's the issue. So there are 3 buildings there now?
yeah, it's 3 of them maybe.
Yeah.
Are they one single house or they are like duplex?
I think they're duplexes, but I'm not certain about that.
But let me ask a question though. I do. The following. It's my understanding when they built the original building of those condos, they were granted for how many, 15 or how many homes, something like that?
We
Not sure how many
we
they were
don't know, I
permitted
mean,
for. We're not
You
sure
don't
about
know.
that.
yeah,
no.
we
And
didn't
they-
issue the
well-
We're
permit.
dealing with limited
Oh, you,
issues,
okay,
yeah.
so, well, I guess, and then the trustees allow an outside company to build another 3 homes?
As I said, we don't have any idea about that, because that's not, the subject matter of the
Okay.
hearing today is the mansions complaining about enforcement of the special permit for the condominium trust. So there's arguments between these 2 parties, and that's really all we know
So it is
about.
between them and the builders?
Yes, between
Between
whoever.
them themselves.
Yeah, between
Each other.
the developer on one piece of property and the condominium trust on the other.
Correct.
I see.
So that's all we know about at this particular board. I mean, most of the time, the special permit would have been issued by the planning board, and the issues that are handled through drainage and stormwater and all those kinds of things are typically more at the planning board, not here.
Yeah, I see, okay. So, in the meantime, I have to wait until,
Well, as I said, if,
Well, you don't have to wait.
Yeah.
And, again, it's unfortunate if you'd have to, hire a lawyer to do it, but the lawyer could find out all the information about who the trustees are and who to contact and who to send a letter to, and et cetera, and would be able to tell you what your rights are under the circumstances. Yeah.
I see, all
which
right.
is not something we can do.
Thank you so much.
Well, thank you for coming.
Sorry you're going through that.
Yeah, yeah.
All right, so what is going to be the next step related to the issue now?
Well, it's continued to September, it's being continued to September 17th, this matter. It may or may not have a hearing on that point, depending, right? Depending on
If they
whether.
resolve the dispute
Yeah.
before
Because
that date. we
what this
won't-
hearing was, as the chair, acting chair said, was to try to get the building inspector to enforce the special permit, and now the building inspector has taken that action.
I see.
So there may not be any reason, or they may not decide that there's no reason to have that hearing on the 17th.
So,
But we're continuing it to the 17th.
so you're going to be sending another letter, or it may be, or?
No, we don't send a letter, no,
Yeah,
it's just.
no, we won't. It will just, we've announced it tonight, and so it'll be on the 17th of September. And at the 17th of September, we'll either be saying that there's no reason to have a hearing, or there will be people here.
Okay, so you will make a decision by then?
We haven't got anything at the moment to decide.
sure.
There's no
Right.
testimony before us, so,
Right.
other than yours.
Okay, so thank you so much for your answer.
Thank you very much for coming.
Yeah, thank you, appreciate it.
It's all said, I guess, right?
Yeah. Anybody else wishing to speak?
Oh, good, I'm sorry. Well, then
Yeah.
Leroy Walker, 452 Truman Parkway. I was interested in the status of the enforcement action, so you've answered that question. So now I just have a technical question, which is if it's determined that there was a violation of the special permit, does the individual applicant have the authority to negotiate a settlement, or does the planning board have to do that?
Well, that's an interesting question. The enforcement order sends them back to the planning board. And I think whatever they work out, I think that has to get the approval of the planning board. Don't you? I mean,
Well, to the extent it would amend the special permit or change the terms of the special
Yeah.
permit, it would. If it were consistent with the special permit, it wouldn't
Yeah.
have to get the approval of the planning
Yeah.
board. I'm not sure that that answers your question.
Not exactly.
Yeah, I would say, you know, the only reason we would get involved at this point is if there were an appeal again, of something
Right.
else. So I'm not sure about, you know, and we obviously don't know about that, but in terms of, your question was
My
getting it
question was,
resolved?
does the individual applicant have the authority to negotiate a settlement, or does the planning board have to negotiate any settlement? I'm concerned that given the facts that we know thus far, sounds a little troubling. It sounds like some things were done without the authority to do so. My concern is that a settlement by the individual applicant might fall short of what one might construe as both reasonable and appropriate.
I think both the planning board and the building inspector would be involved. I mean, the building inspector is the one that's brought the action to enforce the planning board's order. So I think they would both have to be involved in any resolution.
Yeah, you know, the letter from the building commissioner states that, you know, the client's directed to stop all work, apply for an amendment to the special permit, and apply and engage in site plan approval. So I don't see how a settlement gets you out of this
Not going to the
enforcement.
planning board.
Yeah, I mean, because this is starting a judicial process, essentially. And so if you don't comply, you're going to get hauled off into court. So I don't think working it out between, you know, amongst ourselves and not involving the building commissioner or the planning board is going to achieve anything.
Yeah, the only thing they might be able to work out is some kind of an agreement, at least among themselves, as to
Yeah.
an amendment to the special permit.
Right, or what work is going to
that,
remediate.
you know, that the planning board would agree to. But the planning board would still have to issue the amendment, so they would have to,
Yeah.
So if I wanted to follow this closely, where should I direct my attention?
Well, as I said, we've continued this until the 17th of September.
Mr. Prondak, would he be the one?
I would
to-
be the one to keep in touch.
Mr. Prondak's the one it's really in his hands now.
Yeah,
Okay,
because he's issued the enforcement letter. And,
Okay.
and there's a stop order in place.
And nothing's going to happen here until September 17th. And you're aware of that date, both of you are aware of that date for the continuance of the hearing.
It's gonna be here, or,
Yeah, it would be here. Yeah.
so can we attend?
Oh, of course.
Oh, yeah.
What time is that again?
I don't know, 7:30.
7:30.
Same time, 7, okay.
Yeah.
Yeah.
But
So,
I would-
but right now, it's in Mr. Prondak's hands.
Yeah.
okay. I can get in touch with Joe.
Yeah.
Thank you so
So I
much.
keep watching to see what happens with that.
Have a good evening.
Thank you.
Well, today's my birthday, and I hadn't planned to spend it
This
with
was
the
not exactly-
zoning board of appeals. So
Happy birthday.
We're not going to sing.
what was your question? Oh, no, I know. I know how to catch up with them.
49, huh?
Yeah, right.
Happy birthday.
Congratulations.
Happy birthday. Say hi to Cassell.
Thanks very much for coming. And that concludes our business for this evening. May I have a vote to adjourn?
Sure. All in favor?
Aye.